Hi everyone, welcome back to Hands-Free Studying for the MBE, brought to you by Brainscape. These upcoming questions are related to the civil procedure topics on Erie and Injunctions. Let's get started. Question 1. What is the Erie Doctrine? The Erie Doctrine mandates that when there is diversity jurisdiction, federal courts must apply state substantive law and federal procedural law. Question 2. What law applies when there is federal question jurisdiction? Federal laws. Now remember that the Erie Doctrine only applies in diversity jurisdiction cases, not in federal question jurisdiction cases. Question 3. What's the difference between procedural and substantive law? Procedural laws are laws that define the process by which a case will progress. Substantive laws are laws that provide a right. Now, some laws, such as statutes of limitations, fall in a gray area between the two, and this is where most issues with Erie will come up. Question 4. In diversity jurisdiction cases, assuming that state common law and federal law conflict, what is the first step in the Erie analysis? The first step is to determine the law behind the primary issue and determine whether that law is procedural, substantive, or something in the middle. So if the issue is substantive, apply state law. If the law is procedural, apply federal law. And if the law is something in the middle, then proceed to step 2, which is the next card. Question 5. For Erie analysis, if the law is neither substantive nor procedural, meaning something in the middle, how do you determine which law to apply? There are 3 different tests that you can use. First, the outcome determinative test. Second, the forum shopping test. And third, the balance of interest test. First, for the outcome determinative test, ask, does the choice of law impact the outcome of the case? If so, apply state law. Second, for the forum shopping test, ask, would failing to apply the state law lead more people to want to litigate in federal court? In other words, encourage forum shopping. If yes, then apply state law. And third, for the balance of interest test, ask, does the state have a greater interest in having its own law applied than the federal law? And if so, apply state law. Question 6. Generally, for what types of rules will the balance of interest fall in favor of the state, also referred to as strong state policy rules? These are generally remitter, editor, notice of claim requirements, and issue preclusion rules. Question 7. As a general rule, are choice of law rules substantive or procedural? Substantive. Question 8. As a general rule, are statutes of limitations substantive or procedural? Substantive. Question 9. As a general rule, are elements of a crime or case substantive or procedural? Substantive. Question 10. As a general rule, are burdens of proof substantive or procedural? Substantive. And that's the end of your 10 flashcard study round. To reach full mastery, remember to study in Brainscape. Our mobile and web app uses the latest in spaced repetition techniques, allowing you to optimize your study time and track your progress down to the finest detail. But of course, when you're driving, cooking, exercising, or otherwise unable to navigate the app, be sure to keep listening to the rest of this hands-free studying playlist. No matter what subject you're learning and what method you're studying it, Brainscape helps you rise to your challenge.